Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Orenberg, and this is our season finale, the final episode in our series on making an organizational choice. Over the past episodes, we built a robust 4x7 matrix to analyze general partnerships, limited partnerships, corporations, and limited liability companies across 7 key issues: formation, liability, control, financial rights, continuity, liquidity, and mergers. This framework has equipped you to evaluate trade-offs systematically. So whether you're forming a side hustle, advising a client on a high-growth startup, or preparing for the bar exams by understanding how these entities align, you now have a framework you can use to connect real-world needs with some of the doctrine and theory. But before we close the season, I want to offer this episode as a special bonus, a sort of deep dive into additional and alternative forms that build on or innovate beyond our core 4. These aren't everyday staples or tropes like LLCs or corporations or partnerships, but rather specific tailored scenarios that might require very specific business forms like regulated professions facing malpractice rules, mission-driven nonprofits balancing profit-making with the social good, or even cutting-edge blockchain-based organizations that push the boundaries of what you can do with tokenized governance. We'll explore professional entities like limited liability partnerships, professional LLCs, and professional corporations, social enterprise forms such as B Corps and low profit LLCs, and emerging experiments, which notably include wrapped or statutory decentralized autonomous organizations, which are typically a subset of LLCs but are now emerging as their own form. So, why is this a bonus episode? Well, again, these variants highlight the evolving nature of business law, and it shows how business law adapts to ethical mandates, societal demands, and technological disruption. None of these fit neatly into our matrix as standalone rows, and in fact, many are hybrids of the core types. But we'll reference the 7 issues where relevant. We'll show how these new forms tweak liability, control, or continuity to suit niche purposes, and by the end, we'll zoom out to recap the full matrix, to reflect on key takeaways, and to leave you with some questions to ponder. This episode should tie everything together. It should reinforce why entity choice is about more than compliance. It's about crafting a legal foundation that supports a vision while mitigating pitfalls. Let's start with professional entities. These are designed for licensed professionals like doctors, lawyers, accountants, engineers, or architects. Traditional forms like corporations or LLCs could fall short where state ethics codes and licensing boards mandate professional accountability for malpractice. So you can't fully hide behind a liability shield for professional negligence, as it would undermine public trust and accountability. So in states where professionals need these forms, some states have created specialized variants that blend business protections with the ethical requirements. And that ensures professionals remain liable for their own errors, but it also shields them against general debts or their colleagues' mistakes. Keep in mind, though, that the complexity of entity selection is compounded by the choice of state of formation, and now we're also layering on state licensure or ethical requirements. And professional rules vary jurisdiction by jurisdiction. State statutes on these professional entities varies jurisdiction by jurisdiction. So what works in one state might not work in another. For example, in New Hampshire, lawyers can form a professional corporation, and in Pennsylvania, they may not be able to do that. But the most common form of law partnership is the limited liability partnership. And it's almost famous that you would see a law firm and it would be someone and someone separated by an ampersand followed by an LLP. LLPs are essentially general partnerships that are upgraded for professionals, and they're permitted under statutes like the Revised Uniform Partnership Act in Section 1001. In an LLP, partners enjoy limited liability from the firm's general debts, and they're protected from each other's non-malpractice torts. But they tend to, and again, it does vary state to state, so I have to say tend to, remain fully liable for their own professional misconduct, or their failure to supervise. And in some states, they may be responsible for their partner's malpractice as well. Formation of these is a bit different. There is typically a simple registration with the state to activate the liability shield portion of it. And one way to remember that is if you're ever getting the benefits of limited liability, you almost always have to publicly disclose that. And so that aspect is true here as well. Control and financial rights tend to default to egalitarian splits, like a partnership, unless the agreement says otherwise. Continuity and liquidity are also similar to general partnerships. These are fragile entities that are designed for little exit, low transferability, but they are appropriate and stable for ongoing practices. And again, in RUPA jurisdictions, we have more flexibility around partners coming and going. Mergers are possible, but they need unanimous consent, at least as a default. And they're really uniquely used for law and accounting firms and a few other types. So you get Smith & Jones LLP or Orenberg and Orenberg LLP. You get the benefits of flow-through taxation. You get the simplicity and governance of a partnership, and you get some limited liability. But you can't dodge malpractice suits. Next are professional limited liability companies or professional corporations. So they can be PLLCs or PCs. And again, we're just modeling from some of the forms that we already have. So professional limited liability companies are allowed in some states and not others. And those are variants of limited liability companies where members get liability protection for business debts, like the lease on the office building. But again, they can't get protection. They don't have protection for personal malpractice. And that's to align with requirements of ethics codes. Similar to an LLC, you have to file with the state to create it. You have to have an articles of organization. You should have an operating agreement. You have to specify it's a PLLC. Usually it's a checkbox on a state form. This form is not available in all states, but where it is, it's typically a check-the-box operation. Control can be member or manager managed, so you often have the same flexibility you do with an LLC when available. And continuity is, again, like an LLC, entity-like. So we have survival despite exit. It's a truly separate entity. Liquidity here is moderate. Transfers need consent, and we have to preserve licensing, so there may be limits that are either from the state ethics board or from some other licensing entity that you have to have it only owned by professionals of that particular type. So there might be ethics rules that are bound into this. And so liquidity is not the main design here, but it is possible. And mergers are also possible, but once again, bound by ethics rules. Tax is passed through, and just like any LLC, you can elect for partnership taxation. You could also elect for entity level taxation. So it's ideal for small medical groups, or again, if the state allows it, for accounting firms or law firms. And so we do see this LLC form being used more as the LLC has become more popular. Law firms tend to be somewhat more traditional and less exploratory. So we do see more LLPs than PLLCs for law firms, but in many states, it's a new option. And professional corporations or PCs are once again a special type of corporation tailored for professionals under statutes like the Model Professional Corporation Act. Shareholders enjoy limited liability for general debts, but remain personally liable for their malpractice. And they also, in most states, are liable for any negligent supervision of staff. Formation of these is just like forming a corporation. So you'd file articles of incorporation or a certificate of incorporation. You'd elect a board. You'd have bylaws. And all the requirements that come along with corporations exist here as well. Control is going to be more hierarchical. So this is useful if you want to have a management structure which is different from the flat structure of a partnership. You want to have someone who is doing the management and others who are investing money. And the voting rights and the financial rights are based usually on shares as opposed to one person, one vote. The continuity is perpetual, just like a corporation. And liquidity is higher because now we have a concept of stock, although that stock tends to be restricted to licensed buyers, but there are new opportunities for investments in these type of businesses. And, at least to me, interestingly, private equity firms are more and more interested in acquiring shares in law firms, and it's more possible and easier when they're formed as professional corporations. Professional corporations tend to suit larger practices, like chains, where you wouldn't have just a few partners sitting around a table. They blend corporate scalability with professional accountability. So they're really meant for growth, but they, again, don't permit evasion of malpractice liability. Across these, note the common thread. States vary wildly. So, forming a PLLC in Arkansas for lawyers is different from forming a PC in New Hampshire for accountants. You have to check a variety of local rules. They're not full shields. Malpractice pierces by design, but there are protections against other vicarious risks, and you might get flow through or corporate tax options depending on the form. So, if you have a client who's licensed and practicing under that license, these are often mandatory, and skipping these forms could invalidate insurance or, for that matter, professional licensure. Let's shift to social enterprise forms. So, these are also hybrids, and they not just let, but encourage businesses to pursue profit alongside pursuing public good. So, in my conversations around corporations, we talked about corporate purpose, and there's a predominant view that corporations exist for the profit of their shareholders, which is their owners. And in fact, there are famous cases like Dodge v. Ford, which say that the directors of a corporation can't waste the corporation's assets on giving things away to charity. But we could authorize a type of corporation that has a charitable purpose built in to a for-profit business. And that's where we get these hybrid forms that effectively allow directors or even require directors to consider the interests of stakeholders, meaning people who are not the owners, like considering the community around them or the environment, without breaching their fiduciary duties. So it kind of works around the Dodge v. Ford rule. Benefit corporations, or B Corps, are actually enabled by statute, and there are over 40 states that have followed the model benefit corporation legislation. And this embeds a public purpose in their charters. Basically, it says that directors are either authorized to or required to balance profit with social impact. And it may require public or private annual reporting on progress toward that goal. In fact, that kind of reporting can be necessary to get additional certification through B Labs and other companies. B Labs is kind of like saying you're organic. It's a type of certification that is not a statutory definition. So we have B corporations, which means you've actually filed as a type of corporation in a state that allows it, and you've added things to your charter, and you can be certified as a benefit corporation by organizations like B Labs as well, and they can go hand in hand. So we have an additional element to formation. We have a purpose clause to the Articles of Incorporation or the Certificate of Incorporation. Liability and control mirror standard corporations, so we have limited liability. They're led by boards. The financial rights emphasize long-term value, but again, we have this additional obligation or permission to consider things other than maximizing shareholder value, like stakeholder interests and the environment and the community. The continuity is perpetual, and it's liquid in the sense that it's a corporation, so you can exchange their shares. In fact, the mission could attract investors that want to invest in these type of social benefit organizations. Mergers also fall under corporate statutes. So this is great for companies like Patagonia, the clothing company that wants to give 1% back to the planet. It's a large corporation and it functions well as a hierarchy, but they prioritize sustainability. And they want to avoid shareholder lawsuits against the directors for any decisions that don't maximize profits. I mean, literally giving 1% of your profits away could be seen as a violation of the Dodge v. Ford rule I mentioned earlier. This is a way to get around that. Low profit limited liability companies, or L3Cs, are a LLC variant. And there's about 10 states that offer these. It's a way to have semi-charitable purposes with profit subordinate to mission. In my own opinion, these are less important than the benefit corporation because, again, there's a long-standing understanding that corporations exist to maximize profits for shareholders. LLCs are much newer, much more flexible, and they typically have operating agreements anyway. And you could write an operating agreement that says that the directors are not liable for making decisions that benefit people, planet, and profit or something like that. But if you want an off the shelf option, you can file in one of these 10 states where you get the LLC form and the customizable structure, but you embed into it the idea that the managers or the members can and should try to provide charitable purposes along with profit. These are really not very popular for a number of reasons, including the fact that I'm not sure that they're necessary, but again, they exist. And importantly, these are forms that innovate on core types. So the benefit corporation tweaks corporations for environmental, social, and governance, and L3Cs adapt LLCs for social impact. Again, they're not universal, but there is growing interest among investors to try to put their money in these enterprises. Speaking about things that are growing and emerging, let's talk about some emerging frontiers that I think are exciting. Decentralized autonomous organizations are a type of blockchain based company that uses a combination of smart contracts and on chain voting mechanisms to make decisions in an entirely radical new way, which in some of my literature, my scholarship, I talk about as hypervoting. So shareholders can vote consistently and constantly on all sorts of proposals because this is all done with computer code. It's very fascinating, and there's different ways that states have adopted this. So Wyoming, Tennessee, and to a certain extent, an early form of it in Vermont led with statutes that allowed you to wrap a blockchain-based DAO in an LLC framework. Basically, you can create a hypervoting corporation just by creating this computer program. But states then said, we can recognize these computer program organizations as legal entities, as LLCs, in fact, provided that you file in a particular way. You had to file as a DAO LLC, and your algorithm functioned as your operating agreement or in conjunction with a written operating agreement. A lot of complexity here with what's called on-chain, meaning the code-based, and the off-chain, meaning the operating agreement-based governance. And they're very new, and there's not very many of them. But interestingly, they are clearly a new form where we could structure governance of an organization in a truly new and unique way. So that's interesting. And in addition to that, Utah is creating them or permitting them to be created, has a statute that allows their creation without them being LLCs. They're their own new thing. So there's a lot of development in this area. You get all kinds of interesting and novel forms: token-based, decentralized governance structure, programmable financial rights that could be distributions based on smart contract triggering and reporting in from oracles and all sorts of blockchain-based stuff. The continuity is entity-like, but it's code-driven, and liquidity is high to extreme because token trades are even easier than stock trades in many ways. Mergers are subject to the statute of the state. It's not something that there's been any literature on yet, so we just don't really know whether or not mergers between these type of organizations would work. They're just so novel. In fact, as of mid-2025, there were about 1,000 in Wyoming and only a handful in other states. Super experimental, lots of questions, fascinating, risky, because we don't really know how courts would interpret these things. But it is notable that if you form a decentralized autonomous organization and you don't wrap it in a statute, technically you are carrying on a business for profit with partners. You have a partnership, and there would be unlimited liability for all token holders. And there is some case law that has held all of the token holders in a DAO joint and severally liable, just like a partnership. So there are good reasons to wrap it in an LLC. There are also reasons not to, but for another day, or for, in fact, a whole nother course, we can talk about those advanced forms. For now, I want to zoom back out. Let's close this session by recapping our core concepts. We looked at 4 tropes, 4 types of forms that are not just forms, but emblematic of the ways people organize their business: general partnerships, limited partnerships, corporations, and limited liability companies. General partnerships have no formation formalities, and they can be formed accidentally. And the flip side is you get unlimited liability. There is a presumption of equality between access and rights to finances, as well as obligations to pay. They're fragile. They're not designed to be transferred, and mergers are hard. Limited partnerships are a spin on this, where we have two different kinds of partners: those that are involved in the day to day affairs and are liable for what the business does, and those that are just money, and their liability is limited to what they've invested. These typically are governed by limited partnership agreements, and they do have more formalities like filings. The most formal is the corporation, which has a strong liability shield and a very structured hierarchical approach. We have articles and bylaws and often many other formal documents designating everyone's role within that organization. We have strong limited liability and basically no veil piercing in large corporations. The idea of veil piercing being the liability might be unlimited if someone uses a corporation for nefarious purposes. But when you have very large corporations, it's very hard to blame any one shareholder for that sort of thing. So we have a very strong limited liability shield in the corporate form in particular. They're designed to be hierarchical, where we have management and investors are separate. They are owners, but they are not controllers. They're designed to be perpetual. They're designed to last indefinitely, and they can be merged. They have a whole statutory merger scheme, and there are whole courses on mergers and acquisitions about how to do that. They really are scalable economic powerhouses. And then we get the LLC, this interesting newer form. I was going to say new, but it's not the new kid on the block anymore. We have newer forms than LLCs that are built off of more and more flexibility. And the LLCs combine or allow you to combine many of these different forms. So it's crucial to have an operating agreement so that you have actually defined what you're doing with all that flexibility. I will just also add that sole member LLCs don't have the governance challenges because there's complete consistency between ownership and control. And in that particular instance, we can have a very short form LLC that's easy to form. So they're a really excellent way to protect yourself if you're running a solo practice or a small business that has only one owner. But no form is really best. You have to match the business needs to the particular type of form. General partnerships work best when there's trust, when you know all your partners. Limited partnerships are really designed for funds. And to a certain extent, we can use LLCs to do the same job now, but traditionally, LP meant investment. LLCs are meant to be small and flexible, but people have figured out how to scale them. And corporations are really designed for larger enterprises. Special forms extend all of this. There are professional corporations that meet ethical guidelines. There are social corporations that are designed for impact. And then there's DAOs and other ways of being innovative. So as a lawyer, you have to guide clients through a variety of trade-offs. And as a founder, you want to think about how you can select a form which most closely aligns with your goals. You can customize these things, but customization is expensive and risky. So with that, we have, I think, an understanding in general of how to go about the business of selecting an entity and using corporations in order to drive business forward. And I'm curious, which specialized form intrigued you the most? For me, it's DAOs. I just think it's so cool that there's a whole revolutionary governance model because of advances in technology. But I'd love to hear from you about what you find fascinating. But for now, that wraps up our season of Organized, the Business Law Breakdown. As always, I'm Professor Seth C. Orenberg, and thanks for joining me on this journey. I hope this season clarified how business law empowers decisions that organize people, manage risk, and create lasting value. Law doesn't just regulate business, it organizes it. I'll see you next time.